The territorial nature of law refers to the principle that laws are generally applicable and enforceable only within the boundaries of the territory or jurisdiction in which they are enacted. This means that the legal authority of a law is confined to a specific geographic area, and its application is limited to the individuals and entities present within that area. Key aspects of the territorial nature of law. 1. Geographical boundaries. Laws are created and enforced by the authority of the state, and their jurisdiction is typically limited to the geographical area within the state's borders. 2. National sovereignty. Each nation has the sovereign right to create, interpret, and enforce laws within its territory. No state has the authority to impose its laws on another state, unless through international treaties or agreements. 3. Exceptions and extensions. While laws are generally territorial, certain laws may extend beyond a state's borders under specific circumstances. Examples include extrajudicial jurisdiction. Some laws have extraterritorial application. In cases of serious crimes like terrorism, human trafficking, or corruption, where a state may seek to prosecute its citizens even if they commit crimes outside the country's borders. International treaties and conventions. States may agree to be bound by international laws that affect their citizens, regardless of where they are located. For instance, international human rights conventions may influence the laws of a country, even if it does not physically reside within its territory. For conflict of laws. When individuals or entities are subject to laws of different countries, for example, due to international business, travel, or legal disputes, the conflict of laws arises. Jurisdictions may need to determine which law applies in a given situation. In such cases, courts usually refer to principles like domicile, nationality, or the place of the event to resolve the conflict. 5. International law. While most laws are territorial, international law functions beyond the borders of individual countries. International law consists of rules and principles agreed upon by multiple nations to govern relations between states, such as treaties, conventions, and the rights of individuals, for example, international human rights law. However, its enforcement still depends largely on the willingness of states to comply. 6. Transnational legal systems. In areas like trade, business, or aviation, some laws apply globally. For example, international trade laws affect businesses in many countries, and organizations like the International Civil Aviation Organization (ICAO) set rules that all countries must follow, no matter their own local laws. 7. Consular and diplomatic jurisdiction. A state's consular or diplomatic jurisdiction refers to the ability of its consular officers and diplomats to assist its citizens abroad. Consuls may intervene in legal matters involving their citizens to ensure that their rights are upheld, such as ensuring fair trial conditions or facilitating legal representation in foreign jurisdictions. This extends the reach of a country's legal authority beyond its borders.